examination of Ms. Gibson. Ms. Gibson, you are still under oath.
Sir.
Very good. Ms. Nestor, please proceed.
May it please the court. Good morning.
Good morning.
Ms. Gibson, you and I have met before, but just for purposes of the jury, again, my name is Kathy Nestor, and I do represent Kouri Richins along with my co-counsel. So I wanted to start by just kind of revisiting what we discussed yesterday about your role in this case.
Okay.
So it's my understanding that you are, for purposes of saying it in easy, non-lawyerly way, you're the evidence lady, right?
Yes.
So all the evidence that's in this case kind of comes under your purview, right?
Yes, it does.
And you're responsible for being told when it's located, right?
Correct.
If possible, photographing it where it's found.
Yes.
If not possible, then making a log of where you're told it was found.
Correct.
Keeping those logs, safe and secure, right?
Yes.
Noting on the logs the day it was found, the location it was found, and by whom it was found.
Yes.
Making sure then that it's packaged in a way that it can't be tampered with later.
Yes.
And then storing the evidence in some way that is protected from the public or from tampering.
Yes.
And by the way, where do you store all of your evidence?
In our evidence room in the sheriff's office.
Here, just right across from this courthouse?
Correct.
Right. And that room is locked.
Yes.
And only certain people have access to that room.
Correct.
And whenever anybody goes in or out of that room, they have to sign in, right?
It's a key card access, yes.
Okay. And then ultimately your goal is throughout the investigation, if someone needs to look at something, they got to go through you and you check it out and let them look at it and then check it back in.
Yes.
Right. And then you also, the plan is at trial, you're going to come with a box and you're going to show it to the jury. Some things they may be able to see, some they may not. But ultimately, you're going to hand all that evidence over to the jury. Is that right?
I believe so, yes.
Okay. Now, there is an exception for some types of evidence. For example, we've heard testimony in this trial about blood and bodily fluids and samples of tissue. You don't maintain those, correct?
Correct.
Pardon me?
Correct. Just to clarify, we do have a few items from the medical examiner's office that are stored in evidence.
But not fluid of
No.
nature, right?
No.
Because most of that is maintained by the medical examiner's office, right?
Correct.
Or the labs where those items were shipped.
Yes.
Okay. Is there any other type of evidence that someone other than you has a hold of in this case?
Not that I know of.
So one of the pieces of evidence that you are responsible for gathering in this case included the 911 call. Is that right?
I believe so, yes.
And tell us what you did to obtain that call.
I believe I was booked into evidence on a USB.
On a little thumb drive?
Yeah.
Okay. And have you ever reviewed the USB and made sure that the call was in fact on it?
Yes.
And you verified that that was a true and accurate copy of the call?
Yes.
All right. Your Honor, at this point, we would move to admit State's Exhibit 2-40, which is the 911 call in this case.
Is this, forgive me, just so I have context, this is the same as the one we've already heard?
I did a little snippet of it in my opening, but it has not come in yet.
Mr. Bloodworth.
Your Honor, it's Ms.
Oh, my apologies, Ms. Sherman.
That's all right, Your Honor. My objection is based on hearsay. Certainly there are portions of that call that may be admissible by the defense, but broad swaths of that, the state would object on the basis of hearsay.
Would you folks approve?
Sure.
No, there's just no sound. We're just waiting for their little sidebar.
Attention, esteemed viewers. If you are hearing this message, it means that you are sadly witnessing a dark moment in the history of legal discourse. Yes, it's true. Law Talk with Mike is experiencing what we in the business call a plot hole-sized lull. This is, of course, due entirely to Mike's, let's say, ambitious approach to preparation. And by ambitious, I mean utterly devoid. Yes, the very fabric of our legal system, as represented by this live stream, has encountered a, shall we say, temporal anomaly. A glitch, a hiccup, a veritable vacuum of action. And who is to blame? Why none other than our esteemed yet woefully unprepared host, Mike. So sit back, relax, maybe grab a snack. This musical interlude is just gonna be a thing. We'll get back to the legal stuff eventually, probably. So to fill the gaping void where insightful legal analysis should be, and due to a lack of any ability to keep your attention, Mike has in his infinite wisdom decided to subject you to this artistic expression. God help us all, please do not hold Mike accountable for this. Bless his heart, Mike didn't quite foresee these moments of dead air when he planned for this whole thing. He clearly has no idea what he's doing, so sit back, relax, and maybe grab a snack. This musical interlude is just gonna be a thing. We'll get back to the legal stuff eventually, probably. Your Honor, I am not a human being. I am the legal representation of my given name. I am the sea, I am a boat, I am the government in God form papers, and the papers are the people, that is not me. Your Honor, as you can see, I do not consent. I do not consent. I do not
Do you recall who you received the 911 call from?
I don't recall off the top of my head, no.
Do you know whether you downloaded it yourself off of a county database?
I wouldn't have access to that. That would only be one of the supervisors in dispatch.
So one of the dispatch people gave you the thumb drive?
I don't know how it got from dispatch to me. It was booked into a locker, I believe,
And what is that?
on our evidence locker. So when it's booked into the sheriff's office, if a deputy books it in, it typically goes into the temporary locker where they drop the key and then we collect it.
Is that what happened in this case? A deputy dropped it off?
I believe so.
How do you typically in other cases gather the 911 called for evidence purposes?
It's either that way. Sometimes I will personally request it if the detective asks me to. But either way, it's just taken from the dispatch center and booked into evidence.
So once that thumb drive got into your evidence room, it was maintained safe the way that we just talked about with all your other evidence, right?
I believe so, yes.
So there's no reason to believe that the 911 call that you have would have been tampered with in any way.
Correct.
Okay. I think that's it, Your Honor, unless the court thinks I need more. Okay. We're going to come back to the 911 call later in the trial. Okay. Court's indulgence for just a minute.
Of course.
As another part of your duties, and I want to use our language really carefully here, so if you could match my language, that would be helpful, okay?
Okay.
Were there calls between Ms. Richins and her family that you obtained recordings of?
Can you clarify?
On about a weekly basis there for a while, were you downloading calls between Kouri Richins and her family?
Are you talking about jail calls?
Your Honor, move to strike and need to approach.
Is clearly faulty. It was tampered with. The person who you think is me has a different haircut. This is my birth certificate. The person is not me, as you can see. I do not consent. I do not consent. I do not consent. I do not consent. The case law of America says that if the person who represents me is the people who are not the papers. I am the boat, I am the boat, I am the boat. I am the boat.
that come up that I need to discuss with the attorneys at sidebar. This will happen throughout the course of the trial. There's no particular significance to any one of them. Second, please do not consider or speculate at any time during this case or during your deliberations about whether the defendant was or is in custody or was in custody at any time. That is not evidence of anything. You cannot consider that issue for any reason. Ms. Nister, please proceed.
Thank you, Your Honor. All right. There was a time where you downloaded home wave calls. Is that correct?
Yes,
Right. And those calls, when you would download them, you preserved those calls in the same way that you did all the other evidence, right?
correct,
So it was kept in the evidence locker. No one could tamper with it or alter it.
correct.
And some of those calls, there were transcripts made. Were you involved in the making of the transcripts of those calls?
No, I was not.
Okay, thank you. All right. So I'd like to go through with you kind of a timeline, I guess is the best word for it,
Okay.
of your activities on this case. And I'm not going to retread what Ms. Shervanak already covered with you. I'm going to try to talk about things that she didn't cover so we don't exhaust the jury, okay?
Okay.
So I want to talk first about the night of Mr. Richins' death when you arrived on the scene. When you arrived on the scene, you did mention there were already people present. Is that right?
Correct.
When you were there, were they still conducting CPR or had they ceased their efforts to try to revive Mr. Richins?
They were not working on him, no.
So at that point, you knew this was going to be a death scene, right?
Correct.
Okay. And was there somebody on the scene that was giving you tasks to complete, or were you just using your best judgment on what you needed to do while you were there?
I was there to assist Detective Woody.
So Detective Woody was the individual that kind of told you what she needed from you at the scene.
Correct.
And when you first arrived, what was it that she said she needed your assistance with?
I don't recall her exact words, but to assist in documenting the bedroom.
Okay. And you did that, right?
Correct.
Okay. And one of the pictures that you took was admitted yesterday. Just a minute. For purposes of the family, this is going to be a photograph of Mr. Richins' body under the sheet in case they'd like to step out. Can we pull up Exhibit 1-7 that was admitted yesterday and publish it, please?
Do it first.
Oh, yeah.
Any objection, Ms. Sherman?
No, Your Honor.
Okay, we'll publish that now. One moment. There.
Okay. And this is the picture that you testified yesterday that you took. Is that right? That morning.
Correct.
All right. Above the head of Mr. Richins, under the bed, there is a crumpled up sheet. Do you see that?
Yes.
And if you look directly above it to the mattress, this is one of those beds. I'm guessing it's one of those adjustable beds that's divided in the middle.
Yes.
But you can see that there is a sheet on the mattress that's the furthest to the bottom of the picture. And there's not a sheet on the mattress closest to the window. Is that right?
Correct.
And do you have an understanding of why there was no sheet on that mattress?
Yes.
What is your understanding of that?
My understanding was dispatch had instructed Kouri Richins to do CPR on Eric Richins and was then instructed to try to get him on a flatter surface for CPR. In order to do that, especially with a male, they're typically larger in weight, and so she instructed her to pull off the sheet in order to get him off the bed.
So in other words, can't lift the body because it's literally dead weight, right?
Yes.
And so the idea is to undo the sheet from the bed and then pull him down to the ground where you could do CPR on a flat surface.
Correct.
And is that because, I mean, I don't even know if you know, is it not successful to do CPR if you're on a cushy surface because you go up and down, right?
Yeah, it's typically a little bit harder on the person.
Okay. All right. And is it your understanding that the sheet that's crumpled up under the mattress that has no sheet on it, that's the sheet that he was pulled to the ground on?
I believe so.
Right. And did you examine that sheet before it was put into evidence?
I don't recall how much I examined it, but I looked at it.
Do you still have that sheet in evidence?
Yes, we do.
And is there any blood on that sheet?
I believe there was on this.
So if there was testimony here by EMTs that blood did not start coming out until after the EMTs were there, is it fair to assume that the sheet was under Mr. Richins when the EMTs were working on him?
Can you rephrase like the sheet
Well, let me
underneath
ask
him?
this way. Why did you feel that that was an important piece of evidence to gather and keep?
Because it was where he died on.
Perfect. That's what I needed.
Okay.
Thank you. All right. You can take that down, Katie. Thank you. You also, I believe, said that you photographed other areas of the bedroom, right?
Yes.
And one of the photographs that you took, I believe, was the photograph of the nightstand, which was exhibit 1-9. Can we please publish that to the jury? Exhibit 1-9. It was admitted yesterday, Your Honor. Oh, thank you. I gotta get a screen on this thing. Okay, and that's the picture that you took as well, right?
Correct.
Now, when you took that picture, there's a wallet on the nightstand.
Yes.
Do you know how that wallet got there?
I believe it was placed there. I don't recall who placed it. It was there when I arrived, but I was told that it was retrieved from the kitchen.
So is it fair to say then that anything under that wallet that might have been residue on the nightstand could have been altered or changed by placing the wallet on the stand that night?
Not by just placing the wallet on top of an object.
Did you ever pick up the wallet and photograph what was underneath it?
Yes, we did.
You did pick up, and where's that photograph?
I believe OME Sessions documented that.
Okay. And did you open the drawers and photograph what was in the drawers of the nightstand?
I don't believe so, no.
Were you aware at that point that a hydrocodone bottle had been removed from one of the drawers?
I didn't know where it had come from, and it was taken with the decedent.
Okay. So you did not take the hydrocodone bottle into your custody?
No.
Did you open it and photograph the inside of it?
I believe that was OME Sessions.
Okay. So you can't testify whether there were pills in it or not at
No.
the time?
No, I cannot.
Did you ever recover that pill bottle back?
No, we did not.
Okay. I thought that was one of the pill bottles you introduced yesterday. Not?
No.
That was a different hydrocodone bottle?
Which hydrocodone bottle are you referring to?
So yesterday you introduced a packet, and you remember we came up and you were trying to
Mhm.
untape the bottle and looked in one of them, but there was
Yeah.
another pill bottle with that one. Where were those taken from?
It's in that same packaging from the master bedroom, the master bathroom, like linen closet area.
Okay, so the hydrocodone bottle you introduced yesterday was found in the bathroom.
That misstates the evidence.
Would you lay some more foundation, Ms. Nestor?
How do you know where it was found?
I was there that day, and it was found in the bathroom.
Okay,
And
So-
when you say it, for my benefit.
I need clarification.
Yeah,
It's not
could
clear
we,
what-
I need
okay,
I'm having pronoun trouble here.
let's
Can you
do
be
this.
specific about which item you're referring to?
Let's make it really easy. Let's pull your package out because you
Okay.
still got them with you,
Yes,
right?
I do.
You got your box. Okay, let's pull out package number. Just a moment. shall find it.
Is it 9-1?
I'm looking. Yes. Okay, may I approach, Your Honor, just for a minute? I forgot. I don't have that.
No, this. Can you take it out? Sorry, make you blow out.
Okay. So that was my bad. I got the bottles mixed up. So the bottle you just looked at was something called
Oops.
monocycline or something like that, right?
Yeah,
And that was a prescription for Ms. Richins.
correct.
Okay. So those were found in the bathroom.
Yes,
And that includes the quetiapine.
quetiapine. Correct.
Thank you.
Yeah.
Okay. And those were found in the bathroom.
Correct.
And where was the quetiapine bottle found?
It was in one of the baskets that was in that linen closet in the master bathroom.
Okay. So what happened to the hydrocodone bottle that was sent with the body of the decedent?
It's under the medical examiner's office protocol to keep that until they're done.
So you don't have that bottle.
I do not know.
So all we have is a picture of that bottle.
Correct.
So it has never been taken for testing by you to anyone.
Correct.
So if there was fentanyl residue in that empty pill bottle from 2016, we won't know it because you never took it to be tested, right?
I was never given the bottle, no.
Okay. While you were there that day, you also did not take any photos of the kitchen, is that right?
Correct.
And you did not take any photos of the kitchen sink
Correct.
or what was in it.
Correct.
And you did not take into your custody any items that were in the kitchen sink, is that right?
Correct.
And you also did not take any pictures of the closet.
Correct.
And later, we've had pictures be introduced. When you did your Matterport walkthrough, we saw an image of a green jacket where the gummies were kind of sticking out of a pocket. That green jacket, you can't say whether that was there the day that you were there or not.
I cannot. And just to clarify, I did take, I think, 2 photos of the closet, just not that side of the closet.
Okay. So you took photos of, and I'm using this from my experience, but in my house, there's a woman's side of the closet, which is much bigger, and a very small man's side of the closet. Is that the way it was set up in Ms. Richins' house?
I don't recall.
Okay. And you also did not go inside the cabinet over the toilet when you were taking pictures of the bathroom and open the cabinet and see if there were gummies in there, did you?
I did not.
Okay. Also, there was a picture that has come in your Matterport where there was a little dot above the refrigerator where you said that some gummies in a clear plastic bag were found, right?
Correct.
And you didn't go above the kitchen and open that cabinet and take any pictures that morning.
No, I did not. You're referring to the morning of the death.
Correct.
Correct.
Thank you for helping me be specific. I'll try to keep my dates straight. So since you were personally the one who knows where every single thing was found, isn't it true that all the gummies, with the exception of the gummies that were found in the jacket in the closet, were all stored high up where children would not be able to reach them?
I believe so, yes.
Okay. All right. Just 1 second. I think we're going to move to another day. Oh, you mentioned when you were describing paraphernalia that you did not see any paraphernalia that day. Is that right?
The day of the death?
Yes.
Correct.
Thank you. I'm sorry. I'm going to get better.
You're
The
fine.
day
You're
of the
good.
death.
Correct.
And you mentioned paraphernalia is things that we might be familiar with, which would be like bongs or vape pens or scales or little baggies you would put drugs in or something like that, right?
Correct.
Things that would store drugs.
Correct.
Is it possible that if someone had, in your experience, when you've been to scenes, have you experienced where people put pills in different bottles than what the bottle actually says they are when they're illicit drugs?
Are you talking about like prescription bottles?
Mhm.
Yes.
So if you saw an empty prescription bottle near the body that had expired 6 years before, could that possibly be paraphernalia? If it was used to store illicit drugs?
If it was used to store illicit drugs, it could be considered.
Okay, thank you. You also, that day of the death, you did not go upstairs at all, correct?
Correct.
You also did not go downstairs.
Correct.
Since then, you've walked through, viewed, videoed, measured this whole entire house. You're aware now that there's a kitchen downstairs, right?
Correct.
And are you also aware that there was liquor stored downstairs?
I was not.
Did you notice in all these tours that you did and videos that there was an actual beer fridge downstairs filled with beer?
On the day of the Matterport, or which day we were?
Any day you were there.
I don't recall.
Did you notice there was liquor bottles in the cabinet in the kitchen downstairs?
I believe there were some. I'm not sure about how many though.
Did you ever photograph any of those?
If I did, it would have been in my overall photographs.
Also, the day of the death when you were taking photographs, did you photograph anything in the kitchen trash?
No, I didn't photograph the kitchen.
All right. Did you notice anything set around the kitchen? For example, cut up limes or drink mixes or anything on the counter? Did you notice any of that?
I didn't enter the kitchen.
Never even went in it.
No.
Thank you for clarifying that. Then I won't waste my time with more questions about the kitchen. Okay. So let's move now to the next time that you were in that house, which my understanding would have been April the 13th of 2022. Is that right?
Correct.
And what was the reason you were there?
We were there to serve a search warrant.
And this is going to seem like a silly question, but I need to make the record. So when you all execute a warrant of a home, do you tell the people in advance, hey, FYI, we're going to be at your house at 9 and we're going to be searching everything you own? Do you do that?
I don't.
No.
No.
As a matter of fact, it's important for searches to be done well and done professionally, that the person not know they're coming, right?
Correct.
And you guys actually take pretty extreme steps to make sure the person's not tipped off that you're about to search their entire house, right?
Correct. But you, just to clarify, I am not law enforcement officer. I'm not sworn, so that's up to the detectives.
I appreciate you making that distinction. I will not suggest otherwise. But you are certainly a critical part of the search process, right?
Correct.
And why is that?
I'm there to document everything and photograph, collect anything of importance.
So really, I mean, you're like the hub of the whole search, right? Like everything's coming to you that they find in that house.
Correct.
All right. So I know you're not a sworn officer. Maybe you don't carry a gun, but you sure are important to the search process, right?
Correct.
Okay. So knowing that and knowing your role, you would never tip someone off that you were coming to search through all their personal belongings, would you?
No.
And is there any reason that you all believed that Ms. Richins knew in advance you guys were coming to her house?
Well, let's find out if she has any knowledge,
Right.
and then we'll know whether or not it's speculation.
I would just ask like a more precise question. I think and I'm not picking on Ms. Nestor, but I think it was you all, and I think we just need a little more.
Can we just limit the
Detail.
question to
Yes.
Ms. Gibson?
It's a Southern thing.
Yeah.
Y'all is just in my
Okay.
I'm
my
not
blood.
picking on her. I just wanted to be clear.
I'll try not to
Would
say
you
y'all.
restate the question and limit it to this witness?
I'm happy to. I will try to keep y'all out of my vocab, but it's hard. It's deep in there. Did you have any reason to know that Ms. Richins either suspected there was a search coming or knew there was a search coming?
Not that I'm aware of.
Okay. So what steps did you, not y'all, what step did you take to prepare to go to that house that morning on the 13th?
I just made sure I had enough equipment to bring to the home, whether it be packaging, tape, property seizure forms, stuff like that.
Was there a debriefing prior where all the officers and you talked about how you were going to approach the home, how you were going to approach Ms. Richins, what the plan was once you got there?
I believe there was a briefing beforehand, yes.
Did you attend that briefing?
I don't recall, but I believe I was in there for part of it.
And how many officers were planning on being at that search, to your recollection?
I couldn't put a number on it. I'm not sure.
Rough estimate of how many people were in that debrief.
I'd say at least 5.
Okay. And when you all got to the scene, did you drive your own vehicle?
No, I drove a evidence van.
And how many police cars do you remember being at the scene that morning or throughout that day?
I don't recall. I'd say at least a couple.
When you arrived on the scene, was Ms. Richins in the home?
I don't believe so, no.
Did she at some point return to the home, or were you not even involved in that process?
I don't believe I was involved in that process.
So you never even saw her that day?
I don't believe so.
At any point were you asked to go check on the items that were in her vehicle when she was stopped that day?
No,
So you don't know what was in her truck the day that she was pulled over?
no,
And no one ever asked you to like say, hey, these items were in the truck where she was removed from during our search?
I don't believe it. So, and just to clarify, you're referring to the April 13th.
Yes, all
Okay.
these questions are the 13th
Okay.
until I switch, okay?
Okay.
So no one asked you to inventory any of the items in her personal vehicle?
No,
Did the search warrant cover the vehicles in the house?
I believe there were 2 vehicles inside the garages that were included. I'm unaware. I wasn't part of that part of the search during her stop, so I'm unaware.
Okay. Do you remember the weather that day?
It was winter. It was cold.
It was really cold, right?
Yeah.
Snow on the ground. Remember when we used to have snow in Park City?
Yeah. Yes.
Okay. All right. How long were you at the house that day? The 13th.
Believe we were there for about a half day. We were there for several hours.
Was there also a member there at the home on that day from the U.S. Postal Service that you can recall?
Yes.
What's his name?
Believe it's Smoot.
Right. Agent Smoot. Why was Agent Smoot there? What was your understanding of his role at the search?
My understanding was pursuant to the search warrant, they were looking for anything that could have been mailed to the house that would have contained drugs or paraphernalia.
Right. And Mr. Smoot works for the Postal Service, so he would be looking for things that were mailed, right?
Correct.
Like illegal drugs.
Yes.
Okay. And to your knowledge, did he ever give you any that day to check into evidence, anything that was an illegal drug or a postage that looked like it was connected to illegal drugs?
Not that I ever recall.
All right. Was it your understanding? You okay?
I just need some napkins. Sorry.
Oh.
Ms. Nestor,
Oh.
I have a scheduling conflict
Yeah.
at 9:30. Is this an appropriate place
Sure.
to pause?
Sure is.
Ladies and gentlemen, this is no fault of the attorneys. I have an unavoidable scheduling conflict from 9:30 to 10:30. We didn't want to lose all of that time this morning. We have gotten as much done as we could. We're going to take a recess. Fair reminder, please don't talk about this case or anything related to it. You are free to talk about everything else, current events, your family's sports, whether the Spurs are actually going to make it to the finals. That's all fair game. But please, no talking about this case. You are allowed to use your personal devices during this recess, but do not use them to post about the case or to do any research, and please avoid any social media or other reports about the case during that time. Thank you for your patience. I promise we'll get back on the record as soon as we can. Please rise for the jury. Folks, have a seat, please. Ms. Gibson, during this break, like overnight, you are proverbially still on the stand. Please isolate yourself. Don't confer with anyone. Okay. The court is in recess until 10:30. Thank you for your time.
You lit a match in the tabloids, watch the fire spread fast. Two little lies in a cradle of glass. You painted halos on shadows, wrote lullabies for ghosts, but the elaborate scheme was conceived in your throat. You played your part like a movie queen, a silver screen lie in a magazine dream. You said they were real, but their points spin. Whispers made flesh, your tonsil twins. Your baby bump hit a pillow with it. Play it, pretend till the truth walked in. The spotlight fades and the lights grow dim. Now who's gonna hold your tonsil twins?
Did he say an hour?
Your script was a mouthful,
I thought he said 5 minutes.
too hard to conceal. You spat out your lines, but choked on the reveal. The truth was a burden you couldn't swallow low down, and the stain of your tail
That's not good.
splashed on your gown. It's hard to keep your story straight when the paper trail shows no due date. You said they were real, but they're born in your spin. Echoes and rumors, your tonsil twins. You dance on the edge just to reel them in. Your whole defense started to spin. Now all that remains is a stain on your chin. Nobody's buying your tonsil twins. Detectives knocked on the door one more, woke you up where the lie was born. Your load of lies, now a sticky mess. Every word you spoke is a stain to dress. You said they were real, but they're born in spin. The verdict comes down, you'll never win. Thirsty for fame and TV shows, you got left drinking from an empty hose. Now the truth's been shown and you're all alone, left all alone with your tonsil twins. Your tonsil twins. You're all alone with your tonsil twins.
Hello, hello. Good morning.
Good morning. This is case number 26 RO00056, People versus Stephen Ross Munson. That's you, sir?
Yep. Who's the people? Roy Loke.
Yes, sir. Would you mind removing your hat for the balance of the proceedings?
Yeah,
Mr. Munson, you were present just a few minutes ago when the court explained the nature of an informal hearing. True?
No, no,
This is Brecken's fault.
no. I was going to drive over there. I didn't even know if my call connected or not. I was going to
Okay.
drive to the court.
All right, Mr. Munson, stand by. Today's the date and time set for your informal hearing. An informal hearing is a non-criminal proceeding. Nobody goes to jail today on this traffic ticket, but it is considered serious enough that Officer Bushy did issue the citation on the date in question, which was January 3rd of this year at about 3 minutes of 11. In the evening, you were operating a 2008 Chevrolet Trailblazer, white in color, on Main Street at near 6th. At that place and time, you were cited for failed to yield right away. The officer's remark, which appears on your ticket, indicates left turn, cut off northbound vehicle required to slam on brakes. And apparently there is an in-car camera video capture of that might be available, but notwithstanding, you have 3 options to protect your rights today, Mr. Munson. You may admit responsibility. The court will attach a fine between 0 and the maximum, and that will close your case. You could admit responsibility with an explanation that you believe mitigates your circumstances. Your third option is to deny responsibility. If you deny responsibility, the court will swear the parties under oath. The officer will testify first. It's his burden of proof today. Then it is your turn to testify. Tell the court what you want the court to consider. And then the court makes a finding of responsible or not responsible. But please remember that because we're in civil court, the burden of proof on the officer is a mere preponderance of the evidence known as the featherweight test. Because we're not accused of a crime, we're not in criminal court, and the heavy burden of guilt beyond a reasonable doubt does not apply. So as to fail to yield right away, do you wish to admit and explain, or deny responsibility?
Deny, but
Very well. Please raise your right hands.
Yeah,
Do you solemnly swear the testimony you shall give before this court shall be the truth?
I do.
Thank you very much. The officer has the burden, Mr. Munson, then it's your turn. Officer Bushy.
Yes, sir. So on January 3rd, 2026 at approximately 10:57 p.m., I was conducting routine patrol in the area of Main Street, approaching 6th Street. I was northbound Main Street. There was also another vehicle traveling in the same direction in the lane to the left of me. As we were approaching 6th Street, well, I should correct myself, as that other vehicle passed 6th Street, I observed a white Chevy Trailblazer that was traveling southbound Main, approaching 6th Street. Suddenly turn in front of the vehicle in the left lane and turn into the parking lot Blind Owl. The sudden turn caused the vehicle that was in the left lane in front of me to slam on their brakes in order to avoid causing an accident. When I approached Mr. Munson, I spoke with him, advised him of the stop. He advised that there was some pedestrians in the road that he was trying to avoid. I advised him I didn't see any pedestrians, and I went and double checked my dash camera, and the dash camera also showed no pedestrians in the road.
Anything further?
Not for me, sir. No.
Thank you. Obviously, you have the right to rebuttal and any other exhibits you might want to submit after Mr. Munson's testimony. Mr. Munson, you're up. What would you like the court to know?
Yeah, an important factor in this is visibility was very poor that night. I don't know where the officer was parked. And, this isn't 11 o'clock at night. So the pedestrians made me tap my brakes. I wasn't going to run right straight through them. And, I did my best to get out of the way. The other car that tapped on his brakes, also, the pedestrians were passing him first. He hit his brakes. I hit my brakes. During the traffic stop, I let the officer know, the pedestrians were the problem. They were crossing an unusual spot from the bar, from one bar to the piano bar across street. So we're not going to run over the pedestrians. And, so visibility, I had a hard time seeing the pedestrians. It was like foggy, light rain night in the dark. So I have no idea how the officer, spotted anything. If he was following the car that tapped his brakes, I don't know where the officer was.
Okay. Anything else you want the court to know?
I'm not going to run over pedestrians. They were in front of my car.
That's probably a good policy.
So this ticket, we need this to be thrown out, even to make me come back to fight a ticket like this. And they had cars pulled over up and down Main Street.
Well, we don't. I mean, arguably you do.
We call it, the locals, I live 2 blocks away, we call it policing for profit. They're just pulling over people and writing tickets, gaslighting. They're micromanaging your behavior, which is not normal. This is a free country. For you to micromanage things is not normal. And I've been watching this for 25 years. And I look at my record. I had other police departments point out, why do you have 20 tickets in your own city? What's going on? And I said, it's policing for profit. It has nothing to do with, safety or driving I'm a local. I know what's going on. But the dark
Say policing for profit. One more time, I dare you.
conditions, rainy, foggy, 11 o'clock at night in the dark, I drive like an old man. I listen to talk radio. I'm not in a hurry to go anywhere. The other car tapped on their brakes for the pedestrians that crossed in front of him. I tapped on my brakes for the pedestrians, made my left turn safely, and I don't know where the officer even was on the road to be making any judgment. Yeah, if you were more than 30, 40 feet away, you can't make any judgment. The visibility was that bad that night. So nobody's, me and the other car were the only ones that could make a judgment.
Okay. Anything else you want the court to know?
Yeah, you don't micromanage people.
Yeah, you mentioned that. Is there anything new you want the court to know?
Not at this time.
Okay. Thank you very much, Mr. Munson. The court returns to Officer Bushi for any potential rebuttal testimony.
Yes, Your Honor. I have dash cam, but before that, I would also like to say this was downtown, so it's very well lighted. As you can see in the dash cam, you won't be able to see there's no pedestrians that walk in the way. The only thing you'll see is white Trailblazer make a left turn in front of northbound traffic.
Very well.
So if you're ready, I have it pulled up.
You may share your screen.
Yeah.
We've got video. I don't see any fog.
Those are bad conditions, visibility wise.
Mr. Munson, your testimony has been received. Procedurally, you have testified. The party with the burden has the right to rebuttal specifically tailored to your testimony. That's what's happening right now. So the court appreciates all your.
But I want to give my narrative spin to the video. Don't believe your lying eyes. Believe my spin on the video.
Remarks and takes them very seriously and into consideration, but your part of the testimonial presentation is done. Thank you.
Okay.
Would you mind running that one more time? Okay. Thank you. officer. So what at least appears to be depicted is the northbound vehicle was fairly proximate to the southbound vehicle, if the court saw that correctly.
Yes, sir.
And the court doesn't believe it saw any pedestrians. But anyway, that's for findings. Is there any other rebuttal testimony you wish to make, Officer Bushi?
No, Your Honor.
All right. The court has heard and received the testimony of both parties in People versus Stephen Ross Munson. The court first notes that the burden of proof in a civil matter is a mere preponderance of the evidence, otherwise known as the featherweight test. In addition, the court does not take into account the driving record of the responding party, Mr. Munson. The court reviews and considers these matters on the merits regarding the episode alone. And thirdly, the court would note that historically, it believes that specifically under oath, both parties are intending to proceed in good faith based upon their best recollection and perception of the events in question. The court believes that there is ample proof as a preponderance of the evidence that the civil infraction of fail to yield did occur. So the court does find Mr. Munson responsible. The fine, Mr. Munson, is $135. That is payable through the pay portal on the 44th District Court website, or you may offer cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. That's due within 7 days. If you wish to appeal this ruling, you have every right to do so by posting a cash bond of $135 within 7. The matter will be placed upon the formal hearing docket of the chief judge of the district, and at that time, the city of Royal Oak would be represented by City Prosecutor Ryan Kaluzny. So $135 is a bond or a fine within 7, and that completes your hearing. Thank you for your patience, sir.
Okay.
Thank you, Your Honor.
Thank you. Good afternoon, sir. What is your name?
My first name is Michael. My last name is May, M-A-Y.
This is case number 260072 ST. Counsel?
Hannah Fogle, appearing on behalf of Michael May for the limited purpose of arraignment. We have
Janelle
reviewed the
Hofius
charging
is to
document
blame
and
for
waived
this.
formal reading. Mr. May would like to plead guilty today, and we are able to proceed with sentencing today, Your Honor.
Yep.
All right,
Please,
sir.
and thank you. Yes, ma'am.
Has anyone promised or threatened you to plead guilty?
No,
You're pleading guilty because you believe you are in fact guilty.
I am. I moved the vehicle. Yeah, I moved the vehicle on private property. Yep, that's me. Yep, I did
Do
it.
you understand that if you are not a citizen of the United States, a guilty plea could affect your immigration status?
That's me.
I am a United States citizen.
Do you also understand that a guilty plea here today could have further effect on your driver's license with the Secretary of State, including another suspension of your driver's license?
I totally agree with that. Yep, I understand that completely. I just want to get this out of my hair. I just want to keep moving onward and upward, ma'am. I don't know what I'm doing wrong, but I just want to keep going forward. Yes, sir.
Just
Okay,
answer her
the-
question. Don't talk when she does.
Don't talk when she
Ticket
does.
alleges, sir, that on or about January 5, 2026, upon 1150 or near 129th Avenue in Wayland Township, Allegan County, were operating a motor vehicle while your driver's license was suspended. On that date and that location, did you operate a motor vehicle, sir?
I did at the gas station. Yes, ma'am.
And was your driver's license suspended or revoked at that time?
It was, ma'am.
All right, you've given me a factual basis to accept your plea. I will do so. And I find that it is knowingly and voluntarily given. The fine on this is
Yes, ma'am.
$200, state cost of $50, statutory cost of $250, the crime victims' rights fee is $75, and there's also a bench warrant fee of $75. That's a total of $650 to be paid. I'm gonna give you 90 days to pay that, sir, okay? If you're not being held on anything else, you should be let out today, and I'm gonna give you 90 days to come up with that money. If you need additional time, though, you can call our clerks and they'll set you up with a payment plan, okay?
Okay,
You're all set then, sir, thank you.
thank you.
Thank you, Your Honor.
I have a seat back here. Michael,
Huh?
you're all set. Have a seat back here.
We'll go back over here. So. Let me out.
Hi. Please.
Good afternoon, what is your name, sir?
Randy.
Review the pre-sentence report. Mr. Perez reviewed it as well as the mental health evaluation that was completed on this case. There are no additions, deletions, or corrections that we can see, and we're prepared to go forward with sentencing.
All right, go ahead.
All right, thanks. So as indicated in the pre-sentence report, D'Anthony's had some challenging issues. It all stemmed from a traumatic brain injury that he sustained back in 2007, where he was attacked in Cleveland, Ohio. He was in a coma for 2 weeks. He was in Metro Health Hospital for several months after that. So it's been a challenge for him since then. He's been on disability ever since then. So for the past almost 19 years, he's been on disability, not able to work. He's been very compliant with Mr. Perez and I during his representation here. He did seek treatment with Signature Health. It's our position that he is suffering from a neurological disorder, that he has bipolar disorder. He suffers from depression and anxiety. He was taking olanzapine as prescribed. He was taking gabapentin as prescribed. Obviously, he also ingests marijuana to help alleviate the pain that he suffers from this brain injury. He was seeing a therapist there at Signature Health, so he was availing himself of assistance. And I think that moving forward, he's going to have to do that to make sure he's on the right path here. As far as the case here, as D'Anthony indicated to Ms. Henley, he was being provided pharmaceutical grade oxycodone pills. He was using those pills. His role in this was that he was holding these for people from out of state. Then he was getting free oxycodone pills that he was using and abusing, clearly. He did sit down with Mr. Geigrich and some representatives of Lake County law enforcement and provided some information, which I think was taken into consideration by the state of Ohio. So he was not the kingpin here. He was holding these pills. He's, again, making bad decisions. He's made a series of bad decisions over the years. Cuyahoga County, obviously, he had a couple of cases in Cuyahoga County. Noteworthy that he was sentenced to community control by Judge Saffold. In one of his more recent cases, he completed his community control without any incident. So he is someone who can be supervised by the court system. Now, Ms. Friend indicates in her report, again, that D'Anthony suffers from major neurocognitive disorder, cannabis use disorder. She does not mention the bipolar disorder, but that is what he was treating for at Signature Health. She recommends dual diagnosis and treatment, continued mental health services with Signature Health, 12-step meetings, case management, and abstinence from all mind-altering substances, which is obviously what D'Anthony will need to do upon his release in this case. He has a very nice family. His mom's a teacher, his sister's a nurse, as indicated in the pre-sentence report. He has family members here today supporting him. So he does have a network of family that support him. And really, D'Anthony, and we've talked about this, he needs to lean on his family, make sure he's making better decisions moving forward. He understands that he has to pay a price for these transgressions. He's willing to do that. He agreed to this plea agreement with counsel in the state of Ohio. So we would ask the court to take all that into consideration. The fact that he has been compliant with community control in the past, we would ask the court to accept the joint recommendation of the state of Ohio and the defense. And if the court on its own would like to give Mr. D'Anthony some non-mandatory time, well, we wouldn't argue against that. Mr. D'Anthony or Mr. Pompey has executed a affidavit of indigency. His Social Security disability benefits will terminate, obviously, since he's incarcerated. So he is legally indigent at this time. So we submit it to court for sentence. Thank you.
Thank you. Mr. Pompey, what do you want to tell me before I impose the sentence?
How you doing, Your Honor? I'm sorry for bringing this to the community, first of all. Second of all, I do things, I don't do the right thing sometimes because my brain is off track. It's off track. But the pill help me cope with I'm going through the pain and the suffering. Yes.
Okay.
All right. Thank
you,
you,
Your Honor.
Mr. Geigerich.
Thank you, Your Honor. The state of Ohio would urge you to accept.
My brain's not good.
Of 4 years. Thank you.
All right. I have reviewed the pre-sentence report and the psychological evaluation. And I have considered what counsel said, what Mr. Pompey has said. I have considered all the factors in 29-29-11, 29-29-12, and 29-29-13. I will adopt the joint recommendation of counsel. And on count 4, I'll impose a definite minimum period of incarceration in prison of 4 years, up to an indefinite maximum of 6 years. That's on count 4. On count 8, a period of 36 months. On count 9, a period of 18 months, credit for 11 days. The sentences in counts 4, 8, and 9 are concurrent to one another. There is a mandatory fine imposed of $7,500, which will be waived due to Mr. Pompey's indigency. Now, this definite minimum of 4 years up to an indefinite maximum of 6 years means that you have to serve, it's a mandatory time, so you have to serve at least 4 years. If you serve any time beyond those 4 years, that is dependent upon the criteria established by the Department of Corrections. If you live within the rules, and presumably you'll be out after the 4 years, there is a presumption you should be released after that 4 years. If you are not, then you can request a hearing to challenge that additional incarceration. Regardless, you will, at the most, you will mandatorily be released after that 6 years if they keep you any longer than that 4. When you are released, though, you will be on post-release control to the parole authority for at least 18 months, up to 3 years. They will place conditions on you. If you violate the conditions, the parole authority could return you to prison for up to 9 months for each of your violations, up to 1/2 of my sentence. If your violation is a new felony, then you could get an additional consecutive prison sentence for the violation, the maximum of which is the greater of 12 months or the time left under post-release control, and the costs are assessed. Is there anything else, Mr. Geigerich?
Thank you, Your Honor. It'd be the voluntary forfeiture of the firearms and U.S. currency.
If those items are forfeited, the remaining counts are dismissed.
Thank you, Your Honor.
Anything else, Mr. Martinez?
No, Your Honor. Thank you.
All right, good luck, Mr. Pompey.
Thank you.
Statements of the prosecutor are correct. I've had an opportunity to review with my client his constitutional and statutory rights, and at this time I believe he is prepared to make a knowing, intelligent, and voluntary change of plea as described. Thank you.
One question I have for both counsel, does this conviction prevent him from owning or possessing a firearm? Or does it make him a non-qualifying?
Federally. Yes.
Yes. Okay. All right. Thank you. All right, Mr. Cole, how old are you?
Your Honor, I'm 33 years old.
You can remain seated. How far did you go through school?
I have 4 degrees, 2 master's degrees.
Are you a U.S. citizen?
Yes, I am.
And you're able to read, write, and understand the English language, right?
Yes, Your Honor.
All right. Prior to coming to court, have you taken any drugs or alcohol or any prescription medication within the last 48 hours?
No, Your Honor.
Have you ever been diagnosed with or treated for any mental illness?
Yes, Your Honor.
What have you been diagnosed with?
PTSD, anxiety, depression, and adjustment disorder.
Are you treating for any of those conditions?
Yes, I am, Your Honor.
What does your treatment consist of?
I go to therapy once weekly with a veteran service therapist.
Are you prescribed any medication with that?
No, I'm not, Your Honor.
Did you get a copy of the indictment in this case?
Yes, Your Honor.
It's my understanding you're going to plead guilty to count 2, domestic violence, of misdemeanor 1, and then count 1 would be dismissed at sentencing. Is that your understanding?
Yes, Your Honor.
All right, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you some questions. If you don't understand a question, let me know. If you want to talk to Mr. Brown some more, let me know and I'll give you more time. You understand that?
Yes, Your Honor.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. You understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, Your Honor.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine those witnesses. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them testify. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, Your Honor.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes, Your
Are
Honor.
you waiving that right?
Yes, Your Honor.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes, Your Honor.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes, Your Honor.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, Your Honor.
Do you have any questions about any of these rights?
No, Your Honor.
Do you still want to plead guilty to count 2?
Yes, Your Honor.
Do you understand by pleading guilty, you're fully admitting your guilt to that charge?
Absolutely, Your Honor.
And you understand by pleading guilty to this charge that you're voluntarily giving up your freedom for whatever period of time I could sentence you to jail or to community control.
Yes, Your Honor.
Domestic violence is a misdemeanor of the first degree. It carries a 180-day maximum jail sentence and a $1,000 maximum fine. Do you understand that?
Yes, Your Honor.
Do you understand that your conviction wouldn't prevent you from owning or possessing a firearm?
Yes, Your Honor.
Do you understand that I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to jail for 180 days? You understand that?
Yes, Your Honor.
Now, has anybody promised you I would be lenient on you just because you're pleading guilty here today?
No, Your Honor.
Has anybody promised you what I will sentence you to in this case?
No, Your Honor.
Do you understand I don't have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes, Your Honor.
Have you had enough time to talk to Mr. Brown before pleading guilty today?
Yes, Your Honor.
Has he discussed everything about your case and answered all of your questions?
Yes, Your Honor.
Are you satisfied with the advice he has given you?
Yes, Your Honor.
Have you been threatened or coerced in any way to plead guilty today?
No, Your Honor.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, Your Honor.
Do you have any questions at this time?
No, Your Honor.
All right, Ms. Alessi, if the case went to trial, what would the evidence show?
The evidence would show that the defendant and the victim in this case were married at the time of the offense and shared a 2-year-old son together. And on October 5th of 2025 in Lake County, state of Ohio, the defendant came home intoxicated and proceeded to call the victim names, smack her across the face, pull her off the bed, grab and squeeze her around the throat, and threaten to kill her. The victim was able to capture that entire interaction on an audio recording on her phone, which was subsequently provided to the police in this case. When the defendant eventually left the room, the victim grabbed her son and phone and ran from the house and contacted the police. Thank you.
Thank you. Mr. Brown, anything to add to those facts?
No, Your Honor.
Mr. Cole, did you hear what Ms. Alessi said that the facts would show if the case went to a trial?
Yes, Your Honor.
And are those facts true?
Yes, Your Honor.
All right, what is your plea to count to domestic violence and misdemeanor 1?
I plead guilty, Your Honor.
All right, Mr. Brown.
Would you like us to proceed?
Yes, go ahead.
Just do it. Sign it.
I've witnessed the defendant and his attorney sign the written plea of guilty here in open court, and I've signed it as well. May I approach?
Yep. Mr. Cole, is this your signature on the written plea of guilty?
Yes, Your Honor.
Did you sign it voluntarily?
Yes, Your Honor.
Do you want me to accept your written plea of guilty?
Yes, Your Honor.
I'll accept the written plea of guilty. Defendant was present. Mr. Brown advised of all of his rights, made a knowing, intelligent, voluntary waiver. He understands the nature of the charge, the consequences of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. I will accept his plea of guilty and find him guilty of count 2, domestic violence, and misdemeanor 1. I will refer this for a pre-sentence report. Drug and alcohol evaluation, victim impact statement. Sentencing will be March 26, 2:30 p.m. and the bond is continued. Anything else, Ms. Alessi?
No, Your Honor, not from the state.
Mr. Brown?
Nothing further. Thank you, Judge.
All right, we're adjourned.
Thank you.
Two, 6, 1, 5A and B.
Attorney Kouri Westmoreland appearing on behalf of Mr. Nash. Mr. Nash, would you please state your full name for the record?
Right, Nash.
All right, very good, thank you. So today's the date scheduled in this matter for an adjourned show cause on 2/5/1247 and a jail review on 2/6/15A. Okay, and counsel?
Your Honor, I would like you to know Mr. Nash has completed 4 out of 8 anger management courses. He can make a payment of $50 costs and fines. he is back to work, working at American Steel Construction. He's getting everything back on track. He does have a couple matters at Lincoln Park that he's walking himself in on Friday. It's already been arranged. So he's doing good. He's doing good. He's been out of custody for about a month now and working tirelessly to get himself where he needs to be.
All right, and do you have any documentation of the 4 sessions that you've completed, sir?
I don't personally. I thought the counselor did. You might know.
Okay, I don't have that information, so
Yeah, you wanted to know Mondays.
okay, let me take a brief recess and I will check with probation to see if they've received anything, okay? All right, don't go anywhere. Off the record. We're not losing now.
Well, so no, they're not.
I know for sure.
So I was asked. Of course,
She's all pretty good.
Two 51247 matter, sir. It shows as though your balance is $375. All right, you also have a ticket for handicap parking defaulted. Tell me, or Alicia, what's the balance on the ticket? Or R360938?
It's 270.
Okay, so your balance is $270 on that, sir. Okay, so you have $50 that you're paying today, correct? All right, so so is that $50 on each of the 2 cases, or as far as the show causes go, is that 50 on each?
15 total.
50 total, so 25 on each. I can't hear you.
That's fine.
And where are you working, sir?
American Steel Construction, Livonia.
And you just went back to work?
Yes, ma'am. No, I've been back. I went back that following Monday. I got released.
Okay, and so, sir, is your proposed payment plan $25 per month on each case?
I can do 50 per case.
Okay. When can you begin that $50 per month payment? Sorry, I can't hear you. I need you to speak up a little bit louder, please. That'd be March 11th. Do you get paid on a Wednesday or a Friday?
A Friday.
So would you like March 13th, 2 weeks from this Friday?
Just my.
All right, so $25 on each of those files today, $50 per month beginning March 13th. Okay. All right, and then, sir, what we're going to do is we're going to adjourn your jail review out 45 days to make for sure that you are completing your anger management, okay? And so we'll set that out. Mr. Westmoreland, do you have your schedule for April? I don't have that printed yet.
We do.
Okay, what Wednesdays are you here in April?
8th, 22nd, and 29th.
Okay, let's do April 29th. So it's slightly more than 45 days. Okay, and then, sir, just stop at the window and make your initial payment, and you can even get information about paying it online too. Is that a hat, ma'am? You need to make sure that hat's off, please. Is that a hat?
This is a cap. It's not a hat.
Is it a cap for religious purposes or for religious purposes? Okay. All right, thank you. No, Mr. Serrano. I know that, Mr. Serrano,
Okay.
we have your client on Zoom, so we have to handle that.
I know, you're not on the bench when I didn't get in.
I know, but I'm here now. So. Okay. Do you have, Megan Higginson? Thank you. Let's go on the record in the matter of the City of Wyandotte versus Megan Hegelson, 241623A. And 251703A. Counsel?
Your Honor, good afternoon, Richard T. Serrano, 33828, hearing on behalf of with my client. I'm sorry, Your Honor, good morning still. Presently, in the treatment facility. Yes, please identify yourself for the record, ma'am.
Megan Helgeson.
Okay, she's not in the treatment facility, so yeah, she's still at the Wayne County Jail.
Yes, correct.
Okay, and so good morning. Today is the date scheduled for sentencing on these matters on your client's plea of possession of controlled substance on the 241623 and operating while visibly impaired on the 251703. Counsel, do you have an opportunity to review the report and recommendation with your client?
Yes, Your Honor, I have, as to both matters that address and allocate on her behalf. First of all, she tells me she's been in custody on these matters for 76 days. Your Honor, she tells me if nothing else that's ordered, would like to get out of the jail for a couple of reasons. One, her job being held open for her. She would like to keep that job as a church custodian that she's had for quite a while. And the second issue is that her husband is home, virtually paralyzed for this period of time, in need of her assistance. She's been sending her older children over to try to provide for her. And Your Honor, yesterday I received an email from a lady named Catherine Cronk. She is my client's mother. Ms. Cronk is presently in hospice in the state of Maryland. And Ms. Cronk tried to arrange, according to her email, because I did not contact her back because I didn't have my client's permission at that time to speak to this person claiming to be her mother. So I did not respond. But in asking my client what's going on with that, she is in hospice. Ms. Cronk is in hospice. Apparently, where my client has stated that her mother tried twice to post a $500 bond on each, and gave some people these monies, and then they've started with money. So
What?
that's what the text was to me, and that's been confirmed by my client. That the attempt was made to bond her out if that was possible, but she was not.
Where was that attempt made?
I don't know, man. Do you have the information about that?
Via Cash App to a friend and acquaintance, and both times.
Okay, I wanted to ensure that it wasn't through a bail bonds company
No.
or somebody purporting to be a bail bonds company. All right, so counsel, your client's been accepted to participate in the treatment court, and that's something your client still wants to do, correct?
This is what she tells me, but can she be released in order to start that? That's first and foremost.
She of course she has to be released to be able to start that.
And when I explained to her, I explained to her what the program was about, and want to make sure that there are no other folds and the like. Their first concern is to get home and get into the street recovery court and get her family in order.
Right. And the court will note, counsel, that there was a bond that was assessed based upon your client's previous failure to appear on the 241623 matter. And then she was arrested on the 1703 matter, which is why this court ordered a cash bond to be posted before your client was released. And so, it's unfortunate that somebody that was to be helping these individuals or this individual out chose to abscond with the money. That's a separate issue, obviously. And so, ma'am, you're ready to begin the treatment court program?
Yes, ma'am. Yes, Your Honor.
Okay, all right. So the court's going to note that after hearing from counsel, reviewing the report, the recommendation, and defendants wanting to participate in the treatment court, the court's going to find that there is reasonable grounds to depart from MCL 769.5. The court's going to also find the following sums to be in the best interest of justice, to be reasonable in proportion to the seriousness of the matter, taking into account the circumstances surrounding Ms. Hegelson and the legislative guidelines. The court's going to order Ms. Helgeson to comply with all terms and conditions of the Regional Wellness and Recovery Court of the 27th District Court, and I'm going to have you, ma'am, meet or come on in on Tuesday, March 3rd at 10 a.m. to meet with Courtney and begin your appointments for the treatment court. Okay?
Okay.
All right. The court's going to order on 251703A. The court's going to order a $300 fine, $100 screening assessment fee, $300 cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50. That's a total of $825, plus the program fees, I believe, are $640, but I could be wrong on that. That's something, ma'am, that you can take care of while you're in the program.
Okay.
And then as to the 241623, the court's going to order a $200 fine. I'm not ordering a screening. $300 cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50. Is there a warrant fee on that one?
On the 24 matter, yes, there's a $50 warrant.
Okay, and the $50 warrant fee. Total of $675. Okay, so ma'am, make sure you're coming on in here on March 3rd at 10 a.m. to meet with Courtney.
Okay, will I be released today?
You should be, yes, unless there's some other hold somewhere, you should be released today, ma'am.
Thank you so much, Your Honor.
All right, good luck to you.
Thank you.
Your Honor, may I be excused for 30 seconds, bring my client back in?
Which client is that?
That's, Miss, McGee.
Is who?
McGee, we have a resolution, I just, whatever the prosecutor changed something.
Okay, well, just one moment, because I have Mr. Rody ready to go.
I'm ready on that.
Okay, let's go. On the record in the matter of the city of Wyandotte versus Joseph Rody, 251728.
Your Honor, with my, Chief Ronald P. 338, here on behalf of my client, appears to my right. Please state your name for the record. Joseph Brody.
Okay. Thank you for addressing appropriately for court. Today is the date scheduled for the arraignment in the pretrial, and counsel adds to the arraignment.
As the arraignment, discussed the matter with my client regarding the nature of the charges, all maximum penalties involved in this matter. He understands them. He's been advised of his advice of right to be recorded agreement, recorded signature that he has read and understand his advice of right. So we wait for a reading today, stand mute. As per plea of not guilty.
The court will waive the formal reading, enter plea of not guilty for purposes of the arraignment. As the pretrial counsel.
As the pretrial, Your Honor, I was speaking to the prosecutor. We have no objection. Prosecutor obviously has an obligation to contact the alleged victim in this case. So the prosecutor is asking for a short adjournment. We have no objection. So for her to contact the alleged victim. And I believe that we'll have a dispositive agreement after that has happened.
Okay, we can do March 11th, counsel.
That's fine. I'll be here.
There's no talking in court.
And 15.
10:15 a.m. Counsel adds to bond.
Yes, as to bond, Your Honor, my client tells me not on probation or parole. The alleged victim in this matter was a complete stranger, so there'll be no problem with no contact. He is full-time employed at the RV Center. What's the name of it again, sir?
General RV.
General RV, is that full-time?
Yes, sir.
How long have you been there?
Since June.
Okay. We're asking for a personal bond, Your Honor, a bond you can reasonably expect to post under the circumstances.
All right, so this person is a stranger to you and they live out of state, so it really shouldn't be an issue for you to not contact them. Are you currently on probation or parole anywhere, sir?
No, ma'am.
Have you ever failed to appear in court for any reason?
No.
Oh, no. Okay. And my client has no reason to go back to Oak Cafe, Your Honor.
If you're to test right now, sir, what's in your system?
Nothing.
All right,
American.
the court's going to continue your cash bond. You're not to have any contact with Mr. Toth. That's phone contact, text message, email, social media, third party, anything of the like. You're not to return to the Oak Cafe or any other bar. Just have a seat and you'll get a copy of your bond conditions.
Your Honor,
Completed the notice of prosecuting officials as well.
Your Honor, just a quick question. No other bar. There are some very nice restaurants that also serve.
Right, those are restaurants that serve alcohol, but not a bar or an establishment that is a bar that may serve food. So the Oak Cafe is mainly a bar that serves food. Captain's is a bar. The Dot Pub is a bar. Right? That's what I'm referencing.
All right, very good.
Thank you. Have a good day.
Thank you very much, Your Honor.
Just have a seat. You got a copy of your bond conditions. All right, let's see, get Mr. Westmoreland here, please. Okay, or if do you have his number, you can message him.
Westmoreland.
Thank you. I didn't see him either.
Here's.
Oh, okay. So Mr. Zugda's here? Mr. Zugda? Joseph Zugda? We have a hand up him. He's not coming. Guess he will not be here. Okay. Oh no, Ms. Shackelford shouldn't be an FTA. He was in custody.
Oh, okay.
I'm gonna cross that off for you. Well, at least she should be in custody. Let's go off the record. Wayne County Jail. You can sit on mute.
Yeah, this ain't legal advice, but my confidence says otherwise. Woke up early, said I'll be productive. Now I'm deep in a trial like it's abductive. Intent, motive, pause the clip. Rewind that side, did you see that lip? Didn't go to law school, didn't crack a book. But I watched Mike, now I'm legally shook. Tabs open, group chat loud. Bro, that witness just lied, I'm proud. Judge says order, I say it too. Like, sir, I object from my living room. We watch the trials on Law Talk with Mike. Suddenly we all got legal insight. Finger on pause, confidence high. And all that testimony's fried. We don't know law, but we sound airtight. After 2 streams of Law Talk with Mike. All right, chat, slow down, let me clarify quick. No yelling, no petition, don't make you legit. I'm just here with the law in a neutral tone. Y'all turning every arbitration to a felony charge alone. Yes, I see the comment, no, that's not how it works. No, you can't survive feelings or courtroom smirks. I say maybe, chat, here's case closed. I say context, I build a legal manifesto. I blink once, super chats ring, Mike and Clayton, now I'm trending again. We watch the trials on Law Talk with Mike. Half lawyers, half for wrongful hype. Reading body language like we're trained. That blink was weird, I'm just saying. We don't know law, but we feel airtight. After 2 streams of Law Talk with Mike. Mike says allegedly, I repeat it twice. Covering myself, cause I learned that's wise. Now every argument in my life, I preface like, Your Honor, my wife. I'm diagnosing guilt in pajama pants with a Bluetooth speaker and a justice stance. Algorithm knows I'm in too deep. Next video, top 10 courtroom side eyes rank. Verdict drops, chat explodes, caps lock feelings, emotional load. Mike says, remember these are real lives. We never respectfully then refresh 5 times. Court adjourn now, autoplay, same case, new take, let's litigate. We watch the trials on Law Talk with Mike. Internet jurors overnight. Not a badge, not a tie, just vibes. And a strong opinion we will not hide. We don't know law, but we love that mic. Breaking it down so we feel alright. Yeah, like, subscribe, objection, sustain. See you tomorrow. Same case, new brain.
Yeah, this ain't legal advice, but my confidence says otherwise.
You are here in the small claims division of 3B District Court. The rules are relaxed, they are not as strict as they are in the general division of the court. We don't strictly follow the rules of evidence or procedure. Neither party is allowed to have an attorney in small claims court. Raise your right hand. You all swear or affirm that any testimony you are about to give in this matter will be true, to the best of your knowledge and belief. There is no formal record in small claims court, and there is no appeal. Any decision made here is final. Either party has the right to remove the matter from the small claims division to the regular division of the court, where you could sue for up to $25,000. But you would have to tell me before we begin. Once we begin here, any decision made here is final. Raise your right hand. Do you all swear or affirm that any testimony you are about to give in this matter will be true, to the best of your knowledge and belief? To the best of your knowledge and belief. To the best of your knowledge and belief. The best of your knowledge and belief.
Friday night. I'm in a mood. Definitely don't call me to bail you out, dude. I'm just not feeling it. I'm telling you straight. Oh, wait. Is this case great? I think I know this guy. He's back again. This is gonna be good times, my friend. Your Honor, I apologize for how I fled the scene. I just had to get out of the Thunderdome, if you know what I mean. I was in a little pain my first time in the court, but I'm back with my complaint of a very special sort. There's an infestation, Judge. It's truly hard to bear. There's a critter in my trailer and it's living under there. Is it a mole? Is it a rat? He just doesn't know, but it's bigger than a cat. Mike says, is this the guy? The beaver mole guy. He was crazy the first time. infestation is no laughing matter, but this whole dang story just gets madder and madder. The court sent an inspector to check the holes and poop, but he was hired by Mr. Weasel, and I'm in a feedback loop. He's my next door neighbor, he's not insured at all. He owns another trailer park, he really has the gall. It's a major conflict of interest, it's totally absurd. He's the burglar investigating himself, take my word. Oh my God, Mike just can't breathe. A landlord inspector hired by Mr. Weasel. You won't believe. It's a good thing I didn't start cocktailing before this one. The beaver mole guy is just way too much fun. The judge says, where's the escrow? The rent for November. He says, oh, I just forgot. I didn't remember, but I got it, Judge. Don't worry, the money is secure, but the inspector's report is clearly perjury for sure. I was not prepared for this denial of reality. I'm talking point number 17 specifically. Is it a mole? Hey. Is it a rat? Hey. He just doesn't know, but it's bigger than a cat. Mike says, is this the guy? Hey. The beaver mole guy. He was crazy the first time. Oh my, oh my. A beaver infestation is no laughing matter, but this whole dang story just gets madder and madder. The judge said, hold on, son. I'm getting quite confused. We were talking giant beavers, now I feel a bit abused. He says, my trailer's closest to the woodline and the lake. That's where the big beaver-like thing gave me a shake. But the skirting's done. So now I know the deal. The baseboards are ground zero. That's what's real. This is one of my favorite cases. I'll say it before it's over. I might have to make a song about this beaver-loving rover. So, y'all behave yourselves. Stay out of trouble. Don't get hurt. And for the love of God, don't call me. I'm on alert. Just take a damn Uber and leave me all alone with Mr. Weasel and the beaver from the Thunderdome.
Yo, turn the beat up in Vaughn's dictionary. We ain't spelling right tonight. Nah, we spelling wrong. Step in the courtroom. Words all twisted. Sheriff Vaughn speaking like logic got evicted. Mirandarization, boy, that ain't a word. Whole jury laughing like, what did we just heard? Unlogical motions, compellment too. He reiterate nonsense like deja vu. Try to squash, not quash his own case in flames. Even spell check filed the motion saying, bruh, that's lame. It's a moot point, baby, sinking in the trial. Sheriff Vaughn freestyle, but it's juvenile. Tried to recruit the judge, the clerk, and his crew. But the only thing recused was his brain from the view. Dixon, Tennessee, home of bad boy blunders. Vaughn taking L's like his courtroom thunder. Fired his lawyer, then begged for a hand. Elbow counsel stuck like, bro, this ain't the plan. He's Prosay, no way, thinking he's slick. But he's playing Uno while the court plays chess quick. Every motion's a joke, every word's a crime. Even Dr. Seuss said, man, that rhyme don't rhyme. Requise, recruise, make up what you choose. But every fake word just adds to your blues. Mirandarize this, moot point that. Sheriff Vaughn rap dictionary looking flat. It's a moot point, baby, sinking in the trial. Sheriff Vaughn freestyle, but it's juvenile. Tried to recruit the judge, the clerk, and his crew. But the only thing recused was his brain from the view. Mirandarization, unlogical station, compellment nation, courtroom clown in rotation.
The left lane is less bumpy, just like a living man should be. I've been traveling this way for 28 years before YouTube was even on TV. They call me a living man, but mostly just Eric. I am not for hire, taking no money for my rides, I just travel, and when I do, got my moped in the fast lane, a beautiful corporate name. I'm a living man, this ain't no simple game. My birth certificate's a fraud, illegal fiction, a lie. Your state laws don't apply here under federal statute and code. I learned it all on YouTube, then confirmed the law book. The pages are not with me, but the proof is in the photo I took. Got my moped in the fast lane, a beautiful machine. Going 225, backing up for 50 cc's. Living the American dream. Got the supremacy clause, Article 6. The police will see when they face 15 years for harassing me. The police will see when they face 15 years for harassing me. Moped, fast lane, living man, unlawful, perjury, don't need a license, just a ride, scumbag lawyers. You can call me Eric.
It's without representation as a Prosay.
Oh, good Lord, that was fantastic. One car, one sign, one pair of unzip pants. Ladies and gentlemen, I give you my defending cries, we're going federal. Judge Mike laughs, no big dummy and not a chance, not a nudge. Cite some nonsense, Fourth Amendment too, but this circus belongs to one man, Magoo. Crashed into a mobile sign late at night, hair all wild, pants not tight. Cops roll in, not sure what's true. Was he drunk and cussed or just plain Magoo? Mr. Magoo. My bad. Magoo in a gown, cheeks to the breeze, escapes like a bandit with surgical ease. We're back to 76, classic drunk trick, glove box fixed. Drink after the crash, confuse the test, but come on folks, this is nonsense at best. Defense pipes up, he just had a drink. Nerves were shot, gave him time to think. With his robe half on, buying Colt 45 at a 7-Eleven run. Mr. Magoo, oh, what did you do? Bolted from the hospital, pants still askew, license gone, priors too. Jail feels like home, it's waiting for you. This thing's getting bound over. Smash sign, drunk driver, pants down, $0. Prosecutor sharp, Judge Simpson sly. They see through Magoo's every try. Blood draw missing, excuses thin, but Mike just laughs. It's a lock and win. DUI number 4, maybe fleeing too. Magoo's record is nothing new. He likes jail, it's true. That's where he belongs, old Magoo. Mr. Magoo, oh, what did you do? Crashed your car, pants down too. Drunk or dizzy, head or bruised. Either way,
real.
All right, grab a White Claw. Settle in today. We got a true legal scholar on the docket, a Prosay defendant who's about to teach us all a lesson, though. Probably not the one he intends. A flurry of filings land with a thud. Got a judicial notice to muddy the mud. The judge looks confused by the arrest of judgment. While our Prosay scholar files a motion to squash the whole punishment. The state didn't write back. It's a legal disgrace. And without Mirandaization, he's closing the case. He says, Your Honor, the logic is sound and astute. It all stems directly from a poisonous root. He's serving up his tainted fruit. The fruit, the tainted fruit. From a very illegal poisonous root. This whole damn case you must acquit. Cause it all comes from this tainted shit. The state calls their witness Corporal Javin, so calm. Tales of the threats and the verbal napalm. I'm a threat for a reason. He said with a glare, then a scholar on cross-exam says, hold it right there. To prove that this tree has been poisoned for good, let's play my arrest video. It's misunderstood. Oh geez, here we go. He's playing the tape. He's literally handing the prosecution the very fruit he wants thrown out. You hate to see it. No, wait, you love to see it. The body can rolls a spectacular own. The seeds of his legal demise are now sown. Citing Pennsylvania versus Men's with a confident shout, while refusing for 8 straight times to even get out. When her jaw gets broke, it's gonna be your fault. He's proving the state's case without any halt. He's showing the jury with his own evidence the very fresh fruits of a brand new offense. He's serving up his tainted fruit. The tainted fruit. From a very illegal poisonous root. This whole damn case you must acquit. Cause it all comes from this tainted shit. Then he calls to the stand his one saving grace, his baby mama to plead his whole case. Tell the jury he asks her if you'd be so kind. Am I the retaliating, threatening kind? She swears on the stand he wouldn't hurt a fly, a claim the prosecutor's quick to deny. Now ma'am, about that aggravated robbery. He thought to praise his character and opened up the door for the jury to hear of the crimes he'd done before. And the jury comes back guilty, unanimous. He showed them the video of the crime, opened the door to his priors and based his entire defense on a mispronounced legal theory. He served the jury his own tainted fruits on a silver platter. In the end, it was just a fallacy of a malice of justice.
Up before the dawn, the town's still half asleep. Young Jeff Middleton on the truck, trash pile deep. Count the coins in his pocket, dreaming bigger than the day, wishing he could clean up the town in his own judicial way. He wiped the grime off his brow, took a long hard look, thought about the simple life, the one outside the book. Then a grin cracked through the heat. The truth came clear enough. All I need's Italian sausage and a corn dog. That'll fix me right up. Remember Judge Middleton said all you need's an Italian sausage and a corn dog. When life's got you down and the road's a mess, that'll fix you right up. No more, no less. A young man in a buggy sitting down in court. Tried out the big world, but his joyride fell short. Judge leans forward and says, wait just a minute, son. I know all about rum spring, and I've seen where the road runs. You've been pushing your limits, testing every curve and bend. but if you keep that pedal down, the road will get you in the end. Middleton smiles wide, there's a good advice land. All you need's Italian sausage and a corn dog. That'll fix you right up. Remember Judge Middleton said all you need's an Italian sausage and a corn dog. When life's got you down and the road's a mess, that'll fix you right up. No more, no less. Here comes a man, paper stacked up high, spouting soft city lingo, thinking he's sly. I need proof of jurisdiction. He argues and screams. Middleton leans back. YouTube gets a scene. With a wink and a grin, he shuts the whole thing down. I won't entertain that Jabberwocky clown. Then he lands the truth that makes the courtroom erupt. All he needs is Italian sausage and a corn dog. That'll fix him right up. Remember Judge Middleton said all you need's an Italian sausage and a corn dog. When life's got you down and the road's a mess, that'll fix you right up. No more.
Of the day. We will have you come back tomorrow morning, ready to go at 8:30 a.m. Between now and then, same instructions. Please do not speak about this case with anyone. Please do not allow anyone to speak about the case to you. Please do not read, listen to, or watch any reports about this case from any source. You just have to affirmatively avoid those things. Please don't do any searches on the internet about this case at all. Thank you for your patience. Please travel safe. We'll see you tomorrow morning, 8:30 a.m. Please rise for the jury.
So they quitting for the day? They have a snuggle puddle back in chambers and decide to just knock off for the day?
Ms. Gibson, may I have a brief conversation with you? You don't need the bin. You can leave that there for a moment if you want. Mr. Palmer will watch over it. You can just step to the podium for a moment. I apologize for this delay. Can you be here ready to go at 8:30 tomorrow morning?
Yes.
Okay. Do you understand that you are still, in effect, under oath and on the stand, so you cannot confer with anybody about your testimony?
Yes.
All right. Can you follow that instruction?
Yes.
Very good. I'll see you tomorrow morning, ready to go at 8:30.
Okay.
You'll be taking that bin with you, correct?
Yes.
Very good. Thanks.
Thank you.
Okay. Mr. Bloodworth, anything else on the record today?
No, Your Honor.
Ms. Nestor?
No, sir.
Okay, very good. The court is in recess. Thank you for your patience.
Well, that sucked. I did all that. I did all that running around to fill in the gap, and then these people quit on me. What are you gonna do? What are you gonna do? All right. Thanks for hanging out. I didn't. I thought they were gonna restart, as did everybody else. I have no idea what's going on behind the scenes. There could be issues with witnesses or people not being able to see this, or God knows what. God knows what. Whatever it was, the judge said, fine, we'll punt. Everybody come back tomorrow at 8:30 and we'll go from there. That's all we know, people. And like the first part of the trial sucked. I mean, like that's understandable. That happens. But it was like an evidence tech and it was boring and it was dumb. Like there really wasn't anything to get into. Whatever. We'll take it up tomorrow. Thanks for coming out. I appreciate it.